So welcome everyone to the week 4 tutorial, and we will discuss foundation concepts of judicial review. This is a very important topic because although we've discussed in the last week the importance of merits review, we do know that it is not often the case that you could actually have administrative decisions reviewed by the AAT. Because if you examine the Administrative Appeals Tribunal Act of 1975 Commonwealth, the only time that you can apply for a review by the AAT of an administrative decision would be that the decision was based on, Sarah Manuel says she cannot understand me. Oh, okay. Are the others experiencing the same problem? Sarah Rogers says she could hear me well. Mine is fine. Okay. 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 So Sarah Manon, I wonder if the problem might be yours. Okay. Okay. Very good. Okay. So let's continue. Thanks for the feedback, though, Sarah, because for all I know, there might be in fact problems with the connection or problems from my end. So thanks for telling me about that. So going back, the point about merit review. If there is an administrative decision, your goal would be to try to have it reviewed by the Administrative Appeals Tribunal, mainly because the advantage of a merit review is that not only does the administrative tribunal, look actually also the legality of the administrative decision, it also looks at the factual correctness of the decision. So if there is an error in the decision in terms of how the original decision maker evaluated the evidence, then merits review is the way to go, because if you go to judicial review, for example, for as long as there is evidence to support a decision, that decision will not be interfered with by the courts, because the courts do not step into the shoes of the original decision maker, and the purpose of judicial review is mainly to correct decisions that are contrary to the law. So in the event that, for as long as there is evidence that supports a decision, there will be no scope for judicial review. And so therefore, there's an advantage to seeking merits review. And more importantly as well, the advantage of merits review is that the decision maker is actually in a position to apply policy. And courts, again, because courts are limited to the legality of decisions, they cannot use policy because essentially that can involve political considerations, and neither can courts exercise the discretion that are often given only to the executive decision maker. So therefore, there are constraints to judicial review, and there are huge advantages to merits review. And we've also said that the other advantage of merits review is that it is more of an expeditious process of arriving at a review of an administrative decision. It is non-legalistic, and you don't really require lawyers for that. The filing fees are less, and the usual rules of evidence are not really observed. And so there is a huge advantage to seeking to have an administrative decision reviewed by the Administrative Appeals Tribunal. The main problem, however, is that for there to be an application for review by the AAT, it is a requirement that the administrative decision not only must have been based upon an enactment, meaning a statute passed by the Commonwealth Parliament, but at the same time, that particular enactment must also provide for a review by the AAT. So you have twin requirements there. The administrative decision must be based upon an enactment, and at the same time, that particular enactment must provide that there is the availability of an application for review by the AAT, which means, therefore, that if a decision is not based on an enactment, because we recall that there are at least 3 sources of executive power. One is the Constitution, under Section 61 of the Australian Commonwealth Constitution. The second source of power of the executive would actually be what are known as the implied powers of the executive. So there are inherent or prerogative powers of the executive. So even in the absence of any constitutional grant of power to the executive, for a government to function, there has to be assumed certain powers that belong to the executive outside of the Constitution, like the UK or New Zealand. So in other words, if the decision of the executive is not, and the third source, of course, would be a law or statute passed by the Commonwealth Parliament. So a lot of the powers exercised by the executive is based on the exercise of a statutory grant based on an enactment by the Commonwealth Parliament. Which means, therefore, that if the executive decision is made on the basis of the exercise of inherent powers of the executive, then you cannot certainly have an application for merits review by the AAT, simply because the decision in the first place is not based on a statute or an enactment. But secondly, even assuming that an executive decision is made on the basis of an enactment, that particular enactment itself must also provide that recourse is available with the AAT. So, given therefore the constraints with the with the availability of the jurisdiction of the AAT, the fallback position is that, assuming that somebody does not seek an internal review of the executive decision, internal review being that once a decision is made by an original decision maker, you try to have that decision reviewed within that particular agency by bringing it up to the supervisor, to the manager to review. But even assuming that the internal review is unlikely to be successful, and you know that there is no recourse to the AAT, then you need to consider judicial review. But the problem again is, given the fact that, as we said, judicial review is limited to an examination or a review of the legality of a decision, we know therefore that there are constraints to what judicial review can encompass, because it certainly cannot examine the correctness of a decision on the basis of the facts. So even if there is a factual error, even if that factual error may lead to what may be considered to be an injustice on a party, that is beyond the power of the courts to correct. They can't do anything about that, because courts are not intended to be final arbiters of the correctness of executive decisions. And so therefore there is that limitation. And the other problem is because the judiciary does not really take the place of the executive. It does not put itself in the shoes of the executive, or it cannot substitute its own decision for that of the executive decision maker. The problem is that even if the court were to agree with an applicant that particular remedies are available, or an applicant may be entitled to particular benefits, for example, such as Centerlink, the courts, as we will later see, would actually be powerless to order the executive to act in a specific way. So these are just some of the concerns that we need to examine here in this tutorial. Do we have any questions before we continue? Comments? Okay.
Yeah, I have one quick, man.
Yes.
So in that context, if you're saying that some of this supposed evidence, let's say, wasn't allowed to be re-evaluated by the judiciary, if the executive government deliberately, during its initial review, left out information to cause the controversy in the first place, to help administer or clamp down on a particular individual, it means that taking it to a judicial review would do absolutely nothing to correct the heinous attributes of the government by doing something that they shouldn't have done ethically or legally in the first place. Is that what you're telling us?
The facts you gave are distinct, are different, mainly because you had said that the government was kind of withholding the presentation of evidence or certain things. And because of the particular facts you said, there is a chance that the principles of natural justice will emerge. Because under the rules of natural justice, when the rights or interests or legitimate expectations of an individual are impaired by executive decisions or actions, then that individual must be given an opportunity to be heard. That's one. And secondly, the other aspect of the right to natural justice is that the decision maker must act without bias, must be fair, must be impartial. So the way you presented it today, there seems to have been some kind of an ulterior motive on the part of the executive, which means there is bias, but at the same time, that person, given the example you gave, appears to have been deprived of an opportunity to be heard, which means, therefore, there seems to be a violation of the right to natural justice, which I think we take up in week 6 or week 7. And the violation of the right to natural justice is actually a ground for judicial review under the ADJR Act. And it is also a common law ground that is recognized for judicial review, because the breach of the rules of natural justice means that the decision is unlawful or contrary to the law. So under the specific facts you gave, that will be an instance when actually judicial review is available because of the violation of the rules of natural justice.
Yeah, sorry, Manjo, that's what I figured, but the question still remains. In a judicial review, if information hasn't been presented or then presents itself at a later date, the assumption under the JDR rule is that you can't bring in any new evidence for a decision to be made. So that is my question. If the executive government holds back information or misuses information that could change the outcome, but they don't, forcing a judicial review rather than a merit review, where does the individual stand legally and ethically to be able to defend themselves?
Okay. There are probably certain, that's a very good question, Nicholas, and I'm trying to see if there might be certain facts that are missing, because you mentioned the executive government, but usually when we speak of administrative law, we're looking at the level of the individual who has where a particular executive agency has made a decision, and so therefore at this point, I'm trying to think of an instance where the executive agency, such as Centrelink or the Department of Home Affairs, may purposely withhold information. So I have difficulty there. The other aspect, actually, which I think is really relevant to your question, might be the question of freedom of information. So I think the other point you were alluding to is what happens when the executive government purposely or deliberately tries to withhold information that is meant to be available to the entire citizenry. That's something else. That's a different question altogether, and that's covered by the Freedom of Information Act, which we discuss in week 11. And in relation to that particular question, therefore, we should know that under the Freedom of Information Act, any information that is actually within the possession of a government agency, except the judiciary, is generally meant to be available to the public as a public resource, as a public asset. So the government is not meant to withhold that. But under the Freedom of Information Act as well, there are certain information that certainly cannot be made available to the public, such as matters pertaining to the national budget, such as matters pertaining to national security, such as matters pertaining to intelligence, such as matters pertaining to deliberations of the cabinet. Now, if that is the point you were trying to raise, it relates to information coming from the executive government that they are withholding from the public, that is probably likely to be discussed under the week on freedom of information, which we discuss later on. Now, at the level of an individual who has filed an application with an agency and some of the agency is withholding certain regulations, at the moment, unless the facts are complete, I have difficulty responding to the question, but you did raise a very valid point. But again, as I said, if there is evidence that at the level of an executive agency, which could be the Department of Home Affairs, and they withhold information that should have been given that should have been made available to an applicant who has then been affected because of a decision, there is always the assumption that there could have been a violation of the right to natural justice, which would be contrary to law and therefore subject to judicial review.
But probably exceptionally hard to prove in a judicial review under that format then, if they've withheld the information, because how do you then bring new information to the judiciary to evaluate? That's the question. Yeah. Especially for an individual, not for another organisation, but an individual.
Yeah, you're correct, Nicholas, because the other point is, and because Gary has pointed out here, the issue about national interest, we do recall that one of the crucial elements for there to be judicial review, not only must there be standing, And not only must he be able to cite that there has been unlawfulness, not only must he be able to show that there is an available judicial review remedy, but the other crucial point is actually justiciability. And what justiciability means is that there are certain matters, meaning there's an actual controversy, where the courts will not touch it, mainly because out of deference for the executive. So certain decisions ought to be made by the executive alone, like matters of national interest. The courts will not touch that. Those which involve political considerations, the courts will not touch that because of issues about justiciability, which we've probably covered in week 2. So what it does tell us is that while judicial review is available in general, there are constraints, okay? Mainly because the judiciary is not intended to be the most important or not the most powerful branch of the 3 branches of government, especially because both the executive and the parliament have the distinct advantage in a representative democracy of actually representing the people. So they are the voice of the people. And unlike the judiciary, which the judiciary recognizes, they are political appointees. And so therefore, there are certain things which the judiciary feels is actually beyond its competence and jurisdiction to examine, including those pertaining to national interests and those that might have political considerations as part of the decision-making process. And so, we will try to go back to that in a short while, Nicholas, and we could probably proceed with the with the other points for tonight's topic. So thanks, Nicholas. I like that when that is exactly the whole point about administrative law. The whole point about administrative law in the first place is that it was intended to be there in order to try to correct or in order to try to curb potential excesses of the executive. That is exactly the whole point. And so therefore, it is crucial for citizens and special lawyers to be vigilant about executive decision making. And so, but on the one hand, even if we try to be vigilant about executive decision making, there are constraints to what the judiciary can do. And certainly there are constraints to what the AAT can do, because we know that the Administrative Appeals Tribunal is part of the executive. And you will recall that in the discussion forum, a lot of the other students were talking about how appointments in the AAT appear to be motivated not by merit, but favoritism and political considerations. We've even seen it happen in the Queensland Supreme Court about 2 years ago with the appointment of the Supreme Court Chief Justice. So these things do happen. And so it is with greater importance that we need to be aware of possibility of abuse by the executive of its powers. Okay, but moving on, because we need to cover some. So thanks, Nicholas, for raising that. After studying this topic, you should be able to discuss and explain the concept of legality in judicial review. When an administrative decision is unlawful or contrary to law, the grounds for judicial review of administrative decisions under common law and under the Administrative Decisions Judicial Review Act of 1977. Now, I need to point out that this is just the foundation week where we talk about judicial review, but from weeks 5 all the way to week 10, that's about 6 weeks, we will actually be examining in greater detail the grounds for judicial review. So we're just touching, we're just lightly touching on some grounds for judicial review, but we will be unable to do that tonight because it's a very broad topic. And in fact, that's the bulk of the textbook discussion. So tonight we have about 3 discussion questions, including the quiz question, which we shall be taking up. Now, can I have somebody read discussion question 1 for us, so we could probably begin, looking into the core principles of judicial review. Can I get a volunteer to just read the question for us? Sarah Rogers, yes.
Sorry. Okay, so Sheldon Weng applied for the family tax benefit with the Department of Human Services on the 15th of March 2015, a day after he was granted an Australian permanent residence visa. The new A-Tax System, Family Assistance Act 1999 Commonwealth, provides that an Australian permanent resident who has a FTB child who Wang has is entitled to the family tax benefit. However, under the new regulations passed by the Minister for Human Services, an Australian permanent resident is eligible for the family tax benefit only if he or she has held that permanent resident status for at least 1 year. On account of the Minister's new regulations, the application of Wang for the family tax benefit was denied. Wang's repeated request to the Minister's delegate to reconsider the DHS's decision was denied. Wang has approached you as a solicitor for legal advice. He's thinking of asking the courts to review the administrative decision. In particular, he would like a court to set aside the DHS administrative decision and order the DHS to grant him the family tax benefit. Is a court likely to grant the remedies sought by Wang?
Thank you, Sarah. Is the court likely? Can you say yes or no? Is the court likely to grant the remedy sought by Wang? Okay, very good. No, no, no. There was an answer there. Depends on the assent of the amendments to enactment. Okay, no. Very good. So the answer is no. May I know why? Why do you suppose? I mean, in the first place, tell me, is the executive decision contrary to the law? Is it unlawful? In the sense that it seems to be contrary to the okay. Is it contrary to the law or not? Is it unlawful or not? The executive decision, is it unlawful or not? Is it legal or not? Oh, some are saying it's illegal, some are saying no. Okay, interesting. Let's look at the facts again. So if you look at the primary legislation, which is this, it provides that an Australian permanent resident who has an FTB child who Wang has is entitled to the FTB. So that is what the primary legislation has stated. But under the new regulations passed by the Minister for Human Services, that minister added a new requirement that the permanent resident must have had the status as permanent resident for at least 1 year. So there appears to be a conflict between the primary law and the subordinate legislation. There is a conflict because the subordinate legislation added a requirement. Now, we're going to go to the comment of Sarah about, Green versus Daniels in a short while. But I'm just looking now at, the question of legality of the executive decision.
The first thing I would think about, Manjo, is the fact that the added-on new regulation was passed after the date that he applied, which means most laws under the Constitution cannot be retrospective. If he had his application in and was in line with the original law, he should have been granted it under a merit review. And this is one of the questions and one of the reasons that I said what I said before about them not granting a merit review, pushing them into a judicial review, and the judiciary not being able to override the decision that the government had made, subjectifying the individual to an absolutely abhorrent decision.
Okay. Thank you, Nicholas. Let me just make a few comments there. Okay. Number one, so the whole point about the Administrative Appeals Tribunal Act of 1975 Commonwealth is that it is a law passed by the Commonwealth Parliament, and it is really up to the Commonwealth Parliament to determine under what instances merits review is available. So it is, in fact, a new and recent phenomenon. In fact, if you look at some readings on administrative law, to some, it is a new field of law. It's only been there only in the 1960s, even in the UK. And it was a major innovation in Australia when the Administrative Appeals Tribunal Act of 1975 Commonwealth was enacted by the Commonwealth Parliament. But, if that is the decision of the Commonwealth Parliament, the courts cannot question that. They cannot shoot it down for being unconstitutional because it is within the power of the Commonwealth Parliament. So if the Commonwealth Parliament decides that for there to be merit review, the decision must be based on an enactment, and the enactment itself must provide for merit review. That's what the Commonwealth Parliament decided. So we can't do anything about that. Now, the other point, Nicholas, that you had said was that in general, once a law is passed, and somebody has applied under that law, any changes to the law should not impair whatever previous benefits might be available to a possible applicant or to a possible beneficiary. I would think that you might be speaking of, in criminal law, what would be known as ex post facto legislation, so that there shouldn't be a retrospective application of a criminal law that can impair the rights of an individual. But in general, as far as civil law is concerned, and especially as far as government benefits are concerned, it is really up to the Commonwealth Parliament to decide to withdraw what has originally been given. So even if somebody is entitled to it, and then the Commonwealth Parliament decides to revoke what has been given, the courts are powerless to change that, because that is that is within the power of the Commonwealth to do. So it could be questions like, somebody is entitled to, before there were was that maternity benefit something? There was a time. So if somebody got pregnant and gave birth, you have money. That is subject to revocation by the Commonwealth Parliament at any time, or even revocation by the executive, assuming that there has been delegated authority given to the executive. So the point being here, therefore, is that there is nothing that will prevent the Commonwealth Parliament or even the executive from changing whatever laws or regulations that have been previously passed. Okay, so that is one of the core principles here. So anyway, going back to my point, what we have therefore under the facts is a situation where you have a primary law which did not require permanent resident status for at least 1 year, and then you have a new regulation that requires it, which doesn't seem to have been authorized by the primary legislation. And therefore my question was, is the regulation invalid so that the decision made under that regulation would also be invalid for being unlawful? That is my question. And some are saying no, some are saying yes.
And I'd say yes, it is, Manjo. That's one of the reasons why.
Very good. Why would that be unlawful, Nicholas? Very good. Yes, why?
Because it's not a full enactment of Parliament. The minister can't make arbitrary decisions. They have to put it through Parliament to have it amended by the Parliament themselves.
Very good. So Nicholas has touched upon a very crucial point in constitutional law, that when you have a subordinate legislation, subordinate meaning you have a primary legislation coming from the Commonwealth Parliament, that's called a primary legislation. They delegate certain authority to the executive to enact the details or the flesh of what has been the subject of a primary legislation enactment. The crucial point is that the subordinate legislation must not contravene or contradict the primary legislation. Otherwise, the subordinate legislation or the regulations made by the executive would be invalid. Okay, that is a crucial point. So that's correct. So under the facts, we know that the decision of the executive then is unlawful for being contrary to the enactment. So we're clear about that. The question, however, is, assuming that the executive decision is unlawful, because that is, what's quite clear. Assuming that the executive decision, given that the executive decision is unlawful because it is based on a regulation that is contrary to law, meaning contrary to the enactment, can the court then compel the Minister for Human Services to grant the particular benefits that Wang is entitled to under the enactment? That is the question.
Yeah, the answer is no, Manjo. The best that he could ask for would be that the judiciary were to strike down the decision and recommend that it go back to the minister for maybe another review, merit review.
Very good. And Sarah actually pointed out the case for that. That is Green versus Daniels. So my Sarah Rogers made that point about Green versus Daniels. So that is a crucial point. I'd like you to really, this is one of the important decisions in administrative law, which is Green versus Daniels, and that is that even if the judiciary makes a determination that an executive decision is contrary to law, because it cannot substitute its own decision for that of the executive decision maker, it cannot order the decision maker to act in a particular way. It can't even exercise the discretion that are given to the executive decision maker, even if the executive decision is unlawful. I'm talking about generally, okay? Because when we go to week 10 and examine judicial review remedies, there have in fact been instances when, the judiciary kind of acted in a particular, kind of directed the executive to act in a particular way. But in general, the courts will not, following Green versus Daniels. Now, let's just explore this further, okay? Let's just explore this further. We said that even if an executive decision is unlawful, and in this particular case, the executive decision was unlawful because it was inconsistent with the primary legislation, the act passed by the Commonwealth Parliament. So even if the executive decision was unlawful, we said that the court will not grant the benefits sought by the applicant, because the court cannot substitute its decision for that of the executive decision maker. So if that's the case, what's the whole point, therefore, of applying for judicial review in the first place? So assuming that merits review is unavailable, because let's assume that this particular law does not allow for merit review by the AET. And if you are a lawyer and you know that the court cannot order the executive to act in a particular way, such as by granting particular benefits that are sought by the applicant, what then is the point of seeking judicial review?
Well, the whole point would be that the judiciary would recommend that the Parliament actually go through the process of legislating it correctly within the original law.
You mean the executive?
Yeah, the executive to go through well, no, they'd have to go through the entire process, wouldn't they, with the whole government, not just the executive. They'd have to have both sides of Parliament agree on the changes to the original legislation. And the judiciary could recommend that, but the judiciary couldn't force it.
Okay, that's one view. What do the others say? Can I hear the others?
Well, some judicial reviews provide the answer you're after. Like a case I studied in planning and development law, it was a Manjo Railways versus the West Australian Planning Commission, and what they were after was a remedy because the WAPC took land and overtook the land, that took more land than they should have. So when they quashed what they took, that gave them their resolution. So they don't have to go back through to administration tribunals. So, and if a court does quash a decision,
yes,
administration turns around and does the same decision through the same basis. Starting a whole loop, and that's not going to happen because the administration tribunals don't want that.
So that's correct. Okay, so that's also very good. As Michael pointed out, it's actually not ineffectual because, and we have a comment here from Gary, that it is not ineffectual even if the courts are unable to order the executive to act in a particular way. The fact remains that the courts will strike down the executive decision for being contrary to law. So we know, therefore, that the decision is unlawful. And this was what Nicholas had pointed out earlier. The executive is likely to change its decision to abide by the court decision. So the effect of the judicial decision is not going to be direct, but certainly it has a very powerful effect on the executive, because the executive then has to make sure that its decisions and actions will be in accordance with the court decision, which is in accordance with the primary legislation, because otherwise, they'll end up back in the courts again. Okay.
It's not always 100% helpful to the individual though, because in Michael's case, obviously, if they struck it down, the individuals or the government in question couldn't take that land, and it was reappropriated to whoever owned it originally. But in this case, with the family tax benefit, the individual misses out and would have to wait another year minimum after it was enacted into the original legislation.
Yeah.
Isn't that courts? Isn't that law and everything? You miss out often when you shouldn't.
Sorry, Michael, were you talking to me, or you were making a comment to what Nicholas was saying?
Making a comment. Like, it's all well and good to say this is the perfect scenario, but there's always two sides to the story.
Yeah.
And no one's 100% right. And in this scenario, it's a bit different again because we're talking more black and white being students. But, it's just, that's fact and that's life, Don't always win just because you go and think you're right.
Okay, very good. Now, can I just clarify, is everyone on the same page or are people getting confused now? Because I think this is a good discussion because, you know, we're looking at the political considerations here. It's not all about the law. There are political considerations as to, you know, how the executive may act, as to how the parliament may act. Okay, so all good so far? Okay, very good. We could probably proceed to question 2. Thanks for the comments there. Okay. Can somebody read question 2 for us?
I'll do it, Manjo.
Thank you, Kayla.
You're welcome. Sheldon Wang applied for the family tax benefit with the Department of Human Services, DHS, on 15 March 2015, a day after he was granted an Australian permanent residence visa. The A New Tax System Family Assistance Act 1999 Commonwealth provides that an Australian permanent resident who has an FTB child, who Wang has, is entitled to the FTB. However, under the new regulations passed by the Minister for Human Services, an Australian permanent resident is eligible for the FTB only if she has held that permanent resident status for at least 1 year. On account of the Minister's new regulations, the application of Wang for the FTB was denied. Wang's repeated request to the Minister's delegate to reconsider the DHS decision was denied. Wang has approached you as a solicitor for legal advice.
I think Kayla is having problems with the internet. I think she did, but she was able to finish the question. Okay, so this time you're being asked to provide legal advice. Thanks, Kayla. It's all right. So we actually, you know, got everything there. Thank you. What legal steps would you suggest and why? What would you suggest in terms of providing legal advice?
Yeah, I'll jump in. I guess the first thing you'd want to find out from Wang is what they want to get out of it, and what remedy they're looking for, because that's going to dictate whether you direct them towards the AAT, noting that even if it is an issue of legality, the AAT can still look at it, and it'll just be a non-binding judgment on whether it was an illegal decision. But if, depending on what Wang wants to get out of it, if it was something similar to how it was in the previous question where they wanted the FBD money back paid or something, potentially the AAT would be a better avenue for getting something like that.
Okay. Now, given, Damien, that we don't really know under the facts if review by the AAT is available, because the facts don't say that that particular law allows for a review by the AAT, and let's assume that only judicial review is available. The other basic question we ask is, can there be recourse under the Administrative Decisions Judicial Review Act of a decision made on the basis of an instrument or on the basis of a regulation instead of an enactment? We will recall that at its core, there is the availability of judicial review if a decision is made under an enactment. And then an enactment, as defined traditionally, involves an enactment. So if a decision is made not on an enactment, like the New Tax Systems Family Assistance Act 1999, not on a statute, but on regulations, the question is, does the ADJR Act allow for judicial review of decisions on the basis of an enactment?
Yeah, so my understanding of it is generally judicial review is by default available unless there's a list in the ADJR Act that, if it's an ASIO Act or it's, there's a list of decisions that aren't reviewable. So it's the opposite of merits review. So I would say, as long as the Tax System Act 1999, and as long as the it sounds like that the regulations would be classified as a legislative instrument, and so yeah, it should be open for judicial review.
Okay, so very good. So do not be deceived, because I keep on saying that it must be based under enactment, and I kept on saying it should be based on a statute. In fact, if you look at Section 3, Paragraph 1C of the Administrative Decisions Judicial Review Act of 1977 Commonwealth, there is a definition of an instrument, and that involves executive regulations. And so therefore, those executive regulations, or however you may call them, that are made in pursuance of or under the authority of a primary legislation, or such as a statute by the Commonwealth Parliament, they are still considered subject to judicial review under the ADJR Act. Okay, and there is a decision on this made with Federal Circuit Court in the case of Schittick versus Ackland. Okay, so here that would be correct. You can still apply for judicial review, and of course we've discussed the limitations of judicial. Okay, I was thinking somebody was going to say something. Okay, any questions on this point? We're good. Okay, let's just jump to quiz 3, and then we will go back to discussion question 3. Can I get someone to read quiz 3 for us, so we get a sense of what the correct answer should be? Now, the point being, this is the point. We said earlier that as far as judicial review is concerned, it looks at the legality of executive decisions. And in contrast, if you look at merits review looks at the a decision being correct or preferable. So if it's correct, it's according to whether it's correct according to the facts or according to the law. And when it comes to preferability, it is whether or not the decision is preferable according to the exercise of discretion or according to policies. So there is a wider scope for merits review. When it comes to judicial review, we're only looking at mainly about the legality of an executive decision. The question then is, if a law has given wide powers such to an executive to exercise his or her discretion, would it mean therefore that the exercise of that discretion can then not be subject to judicial review? That is essentially the legal issue there. So is there scope for judicial review when the executive exercises his executive discretion, which is authorized under an enactment? So that is essentially the question there. We're going to go back to your point, Gary, in a short while. So we don't, so we stay on track. I'm going to go back to you in a short while. Okay, can I get somebody to read quiz 3 for us? So that is the legal issue. The legal issue is it within the jurisdiction of the courts undertaking judicial review to examine the legality of the exercise of executive discretion? Because we said, the exercise of discretion is apt for merits review, but generally not for judicial review, because the judiciary cannot cannot substitute its decisions for that of the executive, and it cannot step into the shoes of the executive. So that is essentially the legal issue. Can courts exercising judicial review examine the exercise of executive discretion? Okay, can we get somebody to read quiz 3 for us?
Yep, sure. Okay. The Australian Federal Police Act 1979 provides for the qualifications that individuals must possess in order to be employed with the AFP. It also provides that the AFP Commissioner has the absolute discretion to impose other employment qualifications as he or she thinks fit. Kareem Langkawi, a devout Muslim and naturalised Australian, applied for employment in the AFP in response to a job advertisement on its website. A month after application, he received a letter informing him that his application had been declined because he failed to meet certain security requirements associated with being a Muslim. that were imposed by the AFP Commissioner in the exercise of his absolute discretion to impose other employment qualifications as he or she sees fit under the Act. Langkawi has approached you as solicitor for legal advice.
Okay, so do not read the Australian Federal Police, AFP 1979 Act. Now, these are the options. Can you continue reading them, Damien?
Yep, sure. Okay, so which of the following statements is most correct? Where an administrative decision maker exercises discretion in the making of a decision under an enactment, such a decision can only be subject to merits review by the AAT, assuming the AAT has jurisdiction, and not judicial review since there is no legal question that is involved in that instance. B, judicial review is available to determine if a discretionary power conferred by a statute on an administrative decision maker has been exercised reasonably. C, judicial review is not available in this instance because employment decisions by the AFP involve a political question and is non-justiciable. D, where a statute confers absolute discretion on an administrative decision maker, the exercise of such absolute discretion is beyond the scope of judicial review. Or E, all the answers are wrong.
Okay, very good. Thank you, Damon. Can I just ask all of you to try to provide your answers in the chat box? A to E. What do you think is the correct answer here? A, B, C, D, or E? Aha, very good. Okay, so most of you got the correct answer there, which is letter B. Why is that?
Yeah, I initially I thought, I broke my brain a little bit earlier today over this, or yesterday, so I can't remember. I initially thought that A sounded fairly right, but what you've just said before, like I can't remember what made me think, no, that doesn't sound right, probably just because it said, yeah, no judicial review at all, and then it sort of twigged my brain that, oh no, it should normally be available. Yeah, what you said just before about if it's wide-ranging absolute discretion, there still are limits. Like it can't be, abuse of power and
very good.
And as it's been in the chat box, discrimination and blah blah blah. It's still, it doesn't mean that it doesn't empower someone to be, a king, an all-powerful king.
Very good. As Scaly pointed out, there is such a thing as the Westerly Test. So when there is a decision made by the executive, if that decision is one that no reasonable authority or no reasonable body could have arrived at, then in that case, that is what is known as Westerly reasonableness, and it would be contrary to the law. So for example, let's assume that, so are we clear? The correct answer is B. Very good. So that's quite clear. So in the case, for example, of Minister for Immigration and Citizenship versus Lee, and the case of Associated Provincial Picture Houses Limited versus Wednesbury Corporation, even the exercise of discretion must be done reasonably. So the exercise of discretion must be done reasonably. That is still a core principle of law. So we can ask a question here. So assuming, for example, that the AFP commissioner, assuming that he is empowered by primary legislation to create particular regulations concerning the fitness of officers who could be part of the AFP. And one of the regulations said that no person can be an officer of the AFP if that person has a tattoo. Did I pronounce it correctly? A tattoo? I did, I hope, right? Or if that person is short, maybe because, does not have a height of 4 feet and must at least be 5 feet tall. If there's such kind of requirement, what do you suppose? Would that be valid?
No, it wouldn't be valid under the Anti-Discrimination Act.
Okay, that's one. It wouldn't be valid under the Anti-Discrimination Act. But the other point is, if a decision was made on the basis of that regulation, would that have been the subject of judicial review? When it could be said that it was within the scope of the discretion granted by the legislation.
Yeah, it still could go to judicial review for that reason of discrimination. I mean, as we said before, the judiciary couldn't force an amendment to that legislation, but they could recommend that it goes back to Parliament and be amended appropriately.
Okay, but the facts, Nicholas, what I'd like to point out, the facts I gave, it wasn't so much the enactment itself, it wasn't so much the statute, which provided for height requirements, or the prohibition against the prohibition against applicants having tattoo. It was actually the executive regulation that was based on the enactment. So in that particular case, even when there is discretion given to the executive, that discretion must still be exercised reasonably. So that is the other point there.
But isn't it the case in a lot of these situations like that, where those options are open? What happens is they end up going back to the Parliament, and the Parliament then adds them in appropriately within the legislation, rather than leaving it to an individual to make a decision.
Then the answer is, in general, courts won't be able to touch it, because courts can only strike down as invalid an act that is passed by the Commonwealth Parliament if it is contrary to the Constitution. The courts cannot say that the act is invalid because it is inconsistent with the act. It has to be against the Constitution. So for as long as it is within the competence of the Commonwealth Parliament to legislate, because, for example, it is under Section 51 of the Australian Commonwealth Parliament, then courts will find that particular law to be available, to be valid and constitutional. So any act passed by the Commonwealth Parliament will be measured against the Constitution. The act, any regulation, on the other hand, passed by the executive, will be tested against statutes. It will be tested again, as well as general principles of law concerning what might be legal or unlawful decisions by the executive. Okay. Now, but the other point is, it doesn't mean that in general, the executive cannot make restrictions. For example, if there were a requirement that somebody cannot have a tattoo if that person, were to act in a particular manner, or if there is a minimum requirement because somebody has to be a fighter pilot, the only question is, was it reasonable for the executive to have imposed such requirements? If it is reasonable, and mainly because, in other words, people can disagree, certain agency executive bodies can agree as to what can be correct or wrong in terms of the exercise of discretion, the courts will respect that. Because when you talk about Wensbury and reasonableness, the only time that a decision, and we discussed this, I think, in week 7, the only time that an executive decision will become unlawful on the ground of Wensbury and reasonableness is if the executive decision is one that no reasonable authority or no reasonable body can arrive at that decision. So everyone in general must be in agreement. All reasonable persons or reasonable authority must agree that there is only one correct decision that can be made under the circumstances. But if there's scope for this agreement, you cannot meet the Wensbury standard of unreasonableness. Okay, final question, discussion question 3. Can I get somebody to read discussion question 3 for us? Because again, we're talking here of the exercise of discretion. Can I get somebody to read discussion question 3?
It's like a 9-point font on my screen, Manjo. It's pretty hard.
Good hard to read it. Okay, hang on. We might be able to do something there. Sorry. Can you read that there? Can you read it now, Nicholas?
No, it's even smaller now. I don't know what you did. Went the other way.
Can you read it or not?
Oh, yeah, there we go. All right. The Australian Federal Police, or AFP, 1979 Commonwealth, the Act, provides for the qualifications that individuals must possess in order to be employed in the Australian Federal Police. It also provides that the AFP Commissioner has the absolute discretion to impose other employment qualifications as he or she sees fit. Pursuant to the Act, the AFP Commissioner issued regulations that required applicants for employment in the AFP to pass certain security requirements, including background checks on their ethnicity, religion, social, ethnic, cultural, and family associations. The regulations also stated that the AFP Commissioner or his delegate had the discretion to waive the security requirements for the employment applicants, including the background checks on their ethnicity, religion, and social, ethnic, cultural, and family associations. Boris Kaznov, a Bosnian Serb immigrant and naturalised Australian citizen, applied for employment in the AFP in response to a job advertisement in its website. A month after his application, he received a letter informing him that his application had been declined because he failed to meet certain security requirements and related to his association with a paramilitary group in Bosnia in the 1990s. Kazanov has approached you, a solicitor, for legal advice. He wants to know the likelihood of a federal court acting favourably on his application for judicial review on the decision of the AFP Commissioner, particularly relating to the failure of the AFP Commissioner or his delegate to waive the security requirements for employment applicants, including background checks on their ethnicity, religion, social, ethnic, cultural, and family associations. What advice would you give him?
Thank you. Thank you, Nicholas. What do you think? Is there a ground for judicial review?
Well, under normal circumstances, I would say yes after reading all that. But yeah, I still think there's a ground for it. Whether he get one would be a different story.
Okay, but remember, you're acting as a lawyer. You're meant to be acting here as a solicitor. What advice would you give? What is the likelihood of a federal court acting favorably on an application for judicial review, assuming that the point was to question the validity of the exercise by the commissioner of his discretion not to waive the security requirements for employment applicants? That's the legal issue there. How likely is it for a federal court, to favorably act on an application questioning the legality of the failure of the AFP Commissioner to waive the security requirements based on the exercise of his discretion?
Hi, I would say that it's unlikely that they would intervene, basically because case laws indicated, well, that they won't not look into the fact of absolute discretion. They won't give them unfettered rule, but when it involves discretion, the decision maker is given a wide latitude.
That's right.
So they're unlikely to be successful in this case.
That's right. I agree with Sarah. So where there is discretion given to the executive, the courts are likely to respect the exercise of such a discretion, because remember, as we said, the job of the courts is not some kind of a court of appeal. Neither is it meant to be a branch to oversee that all decisions made by the executive are correct. The job of the courts is simply to examine the legality of executive decision making, and for as long as the decision is within the parameters of the law, and especially where the executive is given wide latitude to exercise a discretion in any way, then that exercise of the discretion will be legal and valid.
I was also going to add the fact, because the statute actually mentions various things, ethnicity, religion, social, culture, etc., and because the minister has given a reason that they had suspicions it was involved in a paramilitary group, it would well be within the grounds of the act that was mentioned.
Very good. Now we're going to be examining these grounds for judicial review in greater detail, starting in week 5. We will examine that. There'll be more as we dig deeper. It will be more interesting. Like, for example, assuming that in the course of a background investigation, it turns out that Boris Kashanov, the guy in our example, his only association was that he was a cousin of a member of a paramilitary group. He was in fact a professor in Bosnia, not involved in a paramilitary group, but he was associated in a sense with the paramilitary group because his cousin was a member of the paramilitary group. And if the executive, therefore, if the AFP Commissioner, therefore, disqualified Boris Kashanov on the basis of that association of being a blood relation to a member, will that exercise of the discretion still be subject to judicial review, and in the sense that how likely is it for a federal court to overturn the exercise of the discretion by the executive? Now, we don't have to answer that tonight, because I'd like to give you a chance to examine that in greater detail when we examine Wednesday and reasonableness, I think in week 7. Okay, any questions before we end tonight's session? Comments? Okay, from Lindsay. Again, I am failing to understand how this is not a breach of not only the UN Convention on Human Rights, and specifically the right to freedom of religion. Okay. Let me just, I don't know the background there, okay, because there has been a previous discussion. Before we end it, let me just address a little bit what Lindsay, has importantly raised. Let's assume that there appears to be a violation of certain human rights as based on the Convention on Human Rights, okay? Let's clarify. There is no Bill of Rights under the Australian Commonwealth Constitution. There is no Bill of Rights, unlike the US Constitution. And so therefore, there is a limited set of human rights that are recognized under Australian law, which are not available. So therefore, there are certain human rights which are not available in Australia, but are available in other countries. That's one. The second point is that even assuming that that Australia was a party to the UN Convention on Human Rights, and I'm not sure if it is or not, but assuming it were a party, the mere fact alone that Australia might be a party to the UN Convention on Human Rights doesn't mean that the content of the treaty obligations would then be incorporated as part of Australian law. Under the principle of incorporation, any treaty obligation of Australia, in order for it to be part of domestic law in Australia, must be incorporated in a statute. There can potentially be a breach of international law obligations, potentially, but there can be no breach of Australian law for as long as any treaty obligation has not been incorporated in a statute under domestic law.
We've only got to look at our immigration laws to see that over and over again, Manjo.
Yeah, indeed. Okay, so, okay. Let's not get into constitutional law because that can get really confusing. Sarah, you're far ahead of us. Thank you, though. Okay, so any questions before we end tonight's session?
Yes, sorry. Next week, do we have a tutorial? Because I know it's study break, but I know we've got Christmas coming up and things like that. So I wasn't
we
sure
don't have a tutorial next week because it's the term break. So we're meeting 2 weeks from today. Okay. So thank you very much, and thank you for the, Nicholas and Damien, Sarah, and everybody else, and Michael for being actively involved in the tutorials. And see you again in 2 weeks' time. Bye.